One bad moment can turn a normal police encounter into a criminal case, a seized gun, thousands in legal bills, and a nightmare that follows you for years. Not because you were dangerous, not because you broke some obvious rule, but because you said too much, moved too fast, agreed to something you did not have to agree to, or forgot that your rights can disappear the second you hand them away. When cops want to see your guns, the danger is not always the gun itself. The danger is the moment, the pressure, the confusion, the split second where most people make a mistake they cannot take back. That is what makes this so serious. A lot of gun owners believe that if they are legal, honest, and calm, everything will work out. That belief gets people in trouble every day, because police encounters are not judged by what you meant. They are judged by what happened, what was seen, what was said, what was touched, and what was allowed. And by the time people understand that, it is often too late. The stop is already extended. The search already happened. The gun is already gone. The case is already building. What makes this even worse is that most people do not realize how fast a simple encounter can change shape. A traffic stop turns into questions about a case in the back seat. A neighbor complaint turns into an officer asking to step inside just for a second. A welfare check turns into firearms being taken from a home. A quick look turns into hands on your property, your bag, your safe, your vehicle, your serial numbers. This is where people go wrong. They think the officer is only asking for a small favor. But legally, small moments can open very big doors. These 5 tricks are not street myths, and they are not about acting tough. They are smart, calm, Supreme Court-aware moves that help you protect yourself without acting reckless, hostile, or stupid. They are about staying safe, staying respectful, and not volunteering away the protections you already have. And if you care about protecting your freedom, your money, and your family from one avoidable mistake, this is exactly the kind of information worth staying for. The first trick is simple, but it might be the most important one of all. Never make the officer nervous with your hands. When guns are part of the situation, your hands matter more than your opinions, your explanations, or your confidence. If an officer thinks you are reaching for a weapon, the entire encounter can become dangerous in 1 second. That means no sudden movements, no digging into pockets, no leaning toward the glove box, no reaching under a seat, no turning around to point at the firearm, and no trying to be helpful by grabbing paperwork from the same place the gun is stored. That is how ordinary people create panic without meaning to. This is where common sense beats ego. If you are carrying or there is a firearm in the vehicle, keep your hands visible and wait. If state law requires disclosure, disclose it calmly. If the officer asks where the firearm is, answer plainly and do not move toward it. If your permit, registration, or license is near the gun, say that before reaching for anything. The goal is to lower tension, not raise it. A lot of people think rights are the first thing that matters. In a live encounter, safety comes first because once the scene goes bad, everything else gets worse. And this is the part almost nobody is prepared for. The law gives officers more room when they can point to real safety concerns. The Supreme Court has allowed limited protective searches in vehicle situations, when officers can explain specific facts that made them think a person might be dangerous and could reach a weapon. That means if your behavior looks erratic, aggressive, evasive, or unstable, you are giving the officer a stronger argument to search areas within reach. In other words, your behavior can build the legal case against your own privacy in real time. Picture a normal stop at night. Your heart is racing. The officer sees you moving around in the car before he gets to the window. He notices a range bag. You try to explain too fast. Then you reach toward the center console because that is where your insurance card is. At that point, even if you are completely legal, the encounter is already getting worse. Not because the law changed, but because the facts now look bad. If you want more content that helps you stay calm and avoid life-changing mistakes like that, hit like so more people actually see it before they learn the hard way. The second trick is the one people hate to use because it feels uncomfortable. Do not consent to a search. Not of your car, not of your case, not of your bag, not of the room behind you, not of the safe in the corner. Consent is where countless protections quietly disappear. The dangerous part is that the officer often does not need to threaten you. He just asks in a calm voice. He makes it sound routine. He makes it sound like only guilty people would refuse. And nervous people fold right there. Most people do not realize this, but once you give consent, you can hand the government the very thing your rights were designed to protect. That is why this matters so much. The Fourth Amendment protects against unreasonable searches, but consent is one of the easiest ways around that protection. If you invite the search, many later arguments become much harder. Suddenly, the fight is not about whether they had enough reason. It becomes about whether you voluntarily said yes. And that is not where you want to be. This is also where people confuse politeness with surrender. You can be respectful and still refuse. Those are not opposites. Calmly refusing consent is not aggression. It is not resistance. It is not some magic trick. It is simply not giving away more than the law requires. If an officer already has lawful grounds, a warrant, or a real emergency, your refusal will not stop what they are legally allowed to do. But if they do not have those things, your consent may be the only bridge they were hoping you would build for them. And here is what almost nobody tells you. Even a small look can become a bigger search. A glance into a case can lead to questions about ownership. A look at one gun can turn into interest in another. An officer who sees something in plain view may not automatically have the right to move things around just to inspect hidden details. The Supreme Court has made clear that moving an object to expose something concealed can be a new search. That matters because many people volunteer the movement themselves. They unzip the bag, they open the trunk, they rotate the firearm, they reveal what was not already visible. Imagine standing in your doorway after a complaint call. The officer says he just wants to make sure everything is okay and asks if he can see the firearms everyone is worried about. You think saying no makes you look bad, so you step aside. That one nervous act can change the whole encounter. If this kind of information helps you protect what you own without making a scene, subscribe now, because the next move is the one that stops a bad stop from becoming a fishing expedition. The third trick is to control the clock. Ask whether you are being detained or whether you are free to go. That question matters more than many people realize because time is power during a police encounter. The longer you stay, the more chances there are for more questions, more pressure, more consent requests, more conflicting statements, and more reasons for the encounter to grow. The Supreme Court has made clear that a stop cannot be stretched longer than reasonably needed for its original purpose, just so police can start chasing unrelated suspicions without proper grounds. This is where it gets serious. A traffic stop is supposed to deal with the traffic reason for the stop and ordinary safety checks tied to that mission. What it is not supposed to become is open-ended detention while the officer starts exploring every other curiosity in his head. If the original reason is done, the stop is supposed to end unless something new gives legal reason to keep it going. That matters when the conversation shifts from your taillight speed or lane change to questions about why you own a certain gun, where you were earlier, who else has access to the vehicle, or whether the officer can take a look just to verify a serial number. This is the mistake almost everyone makes. They think staying longer makes them look cooperative. Sometimes it just gives the officer more material, more words to compare later, more chances for nervous contradictions, more chances to ask for consent after you are tired and emotionally worn down. If you are free to leave, leaving calmly may be the single smartest thing you can do. Not storming off, not arguing, just ending the encounter when the law says it should end. There is another reason this question matters. It forces legal clarity into a moment filled with social pressure. If you are detained, then you know the encounter is not voluntary, and you should become even more careful with your words. If you are free to go, then standing there and continuing to explain yourself may only create risk. That simple question helps separate command from suggestion, authority from fishing, and real detention from casual pressure. Think about how many cases begin with a person talking past the point of safety. The warning was given. The ticket was written, but the person stayed. They kept explaining. They answered one more question, then another. Then they agreed to one more request. What happens next changes everything. So keep watching, because the next trick may be the most misunderstood one in the entire conversation about guns and police. The fourth trick is to know where your strongest protection actually lives, and that place is your home. The Supreme Court has repeatedly treated the home as the core of Fourth Amendment protection. That matters because many people panic when police show up at the door and assume they have to let them in, especially if the officer talks about safety, concern, or wanting to clear something up. But concern is not the same thing as automatic authority. A polite request to come inside is still a request unless there is a warrant, a real emergency, or some other lawful basis. This matters even more in gun cases because officers often frame the contact as caution, not accusation. They may say they just want to make sure no one is in danger. They may say they only need to secure the firearms for now. They may imply that cooperating will make things easier. The problem is that once officers are inside, the whole landscape changes. What was private becomes visible. What was hidden becomes plain view. What might have required more legal justification suddenly becomes much easier for the government to talk about later. The Supreme Court has rejected the idea that police have some broad, free-floating power to enter a home and seize guns just because they are performing a general caretaking function. That is a big deal. It means the phrase safety concern is not a magic key that unlocks your front door. At the same time, do not misunderstand this. Real emergencies are different. If officers have an objectively real reason to think someone inside needs immediate aid or there is an urgent danger, different rules can come into play. That is why the smart move is not to argue law on the porch like a talk show caller. The smart move is not to consent casually. And here is the hidden part most people miss. This protection also matters around the area right next to the home, like certain parts of a driveway or enclosed private space tied closely to the house. The Supreme Court has recognized that police do not get to use the usual automobile excuse to wander into protected home space and search a vehicle there without a warrant. That is huge for people who think a car is always treated the same no matter where it sits. Location changes everything. A vehicle out on the road is one thing. A vehicle parked within the protected space of your home is another. Now picture this clearly. An officer is at your door after a report from a worried relative. Your truck is parked close beside the house. There is a case inside. The officer says he just wants to look around and make sure there are no firearms that need to be secured. This is exactly where calm people accidentally give away their strongest legal ground. If you believe more Americans need to hear this before a stressful moment strips their rights away, share this with one person who owns firearms and assumes being nice is enough. The fifth trick is to stop trying to talk your way out of danger. Say less. Much less? This is not about being rude. It is about understanding that nervous explanations often create the very problems people are trying to avoid. When police want to see your guns, every extra sentence can open a new door. Where you bought it, why you have it, why it is loaded, why it is there, who used it last, whether the serial number is intact, whether the case belongs to you, whether there is another one in the house. People think honesty in the abstract will save them. But in the real world, rambling under pressure produces mistakes, confusion, and statements that can be twisted later. That does not mean refuse every lawful requirement. Laws vary by state. In some places, you may have to provide your name during a lawful stop. In some places, there may be duties connected to permits or disclosure. That is why this is not about acting like the internet made you a lawyer. It is about understanding the line between what you must do and what you do not have to volunteer. Provide the lawful basics calmly. Then stop filling the silence with risk. This is where people lose control. They think silence looks guilty, so they start storytelling. They explain the whole weekend. They explain the range trip. They explain the family situation. They explain the old arrest from years ago, even though nobody asked. They explain why the gun is not stolen before anyone even suggested it. They explain the safe, the ammo, the truck, the friend, the brother-in-law, the hunting land, the text message, the argument, the medication, the bad day. And with every sentence, the situation gets harder to unwind. The safer move is simple. Comply with lawful orders. Do not physically resist. Do not touch the firearm. Do not open containers. Do not unlock safes. Do not start proving things unless you are legally required to. If the encounter turns serious, ask for a lawyer and stop trying to rescue yourself with more talking. One of the biggest myths in America is that innocent people talk themselves clear. Many innocent people talk themselves into trouble because stress makes them inaccurate. And in law enforcement, inaccurate can look suspicious very fast. There is also a mental trap here. People assume that if police can see a gun, police can inspect anything they want about it. That is not automatically true. Seeing is not always the same as searching deeper. A gun in plain sight does not erase every boundary around touching, moving, manipulating, or expanding the search. But if you start handing it over, moving it, opening the case, spinning it around, or digging for paperwork next to it, you may destroy the difference yourself. If this is already making you rethink how you would handle a stop, stay with me, because the final piece is the part that makes all 5 tricks actually work. The deeper truth behind all of this is not just legal. It is psychological. Police encounters are pressure tests. And under pressure, most people chase relief, not strategy. They want the officer to like them. They want the tension to end. They want to prove they are one of the good ones. That emotional urge is exactly why people consent, overtalk, invite officers in, reach toward guns, and keep chatting long after the legal reason for the stop should have ended. The mistake is not always ignorance. Sometimes it is fear wearing the mask of cooperation. That is why the right approach has to be simple enough to survive adrenaline. Keep your hands visible. Do not make sudden movements around a firearm. Do not consent to searches. Control the clock by finding out whether you are detained or free to go. Protect the home by not casually inviting the government inside. Give only what the law requires, then stop talking. These are not magic words. They are habits. And habits are what save people when stress tries to take over. What happens next in a real encounter usually depends on what happened first. The first movement, the first answer, the first step backward into the house, the first nervous laugh before opening the trunk, the first sentence that was not necessary. That is why these tricks matter so much. They do not just protect rights on paper. They reduce the chances that the encounter spirals in the first place. They protect against misunderstanding, escalation, and the kind of preventable mistakes that cost ordinary people years of peace. And here is the part I want you to remember long after this ends. You do not have to act tough to protect yourself. You do not have to be disrespectful. You do not have to turn every encounter into a lecture. The smartest person in these situations is usually the calmest one. The one who understands that silence can be protection, that politeness does not require surrender, and that a few careful choices in one tense moment can save a family from financial ruin, legal chaos, and regret that never fully goes away. So if cops ever want to see your guns, remember what most people forget. The biggest danger may not be what you own. It may be how you react. React badly, and you can hand away your freedom piece by piece. React wisely, and you give yourself the best chance to stay safe, stay lawful, and stay in control when the pressure is highest. If you know someone who carries, keeps firearms at home, or thinks this could never happen to them, send this to them now. Like this if you want more clear, protective content like this. Subscribe if you believe knowing your rights before the moment matters more than trying to learn them after everything has already gone wrong.